joining today's. And uh, am I audible? Am I audible?
Yes, ma'am. Yes, you are audible now.
Okay. So I request to all the participants kindly on their cameras if uh, if uh, they are convenient. So we can interact with each other very warmly, and we can understand the topic also. So I request to all the participants, please keep your camera on. Now, I will just share my PPT. One second. Just a minute. I'm just sharing my PPT.
Hello, ma'am. I hope you have not started the session. Nothing is visible and nothing is audible.
Uh, Actually, sir, there is a technical problem. Could you
Yeah.
please wait for a moment?
Yeah, sure.
Sorry for the inconvenience to all the participants. Uh, am I audible?
Yes,
Yes,
ma'am, you
ma'am.
are audible.
Okay. Sorry, sir. Sorry for the inconvenience. I'm just trying to join from the phone because I think there is some network related issue on my laptop. I'm trying, the team is trying to fix it. So I just sharing the PPT. 1 minute.
Maybe just a suggestion. Probably you can share your document to ICSA and they can share the document maybe. Just for information, what in my screen, what I see is all participants, names, nothing else. I don't know about others. Ma'am, you are not audible. I think you are muted.
One minute. Am I audible now, sir?
Yes, now you are audible. What I was suggesting you, ma'am. Again, you are muted, ma'am.
I requested kindly share my PPT on the screen so I can explain.
Your voice is very low, madam.
Now, is the voice is okay?
Voice is fine. Yes. Content is not yet been shared.
Yes, sir, I have seen. I'm just requesting, and otherwise I am trying to join again from my laptop and another connection. I'm trying.
Yes, ma'am. What I was suggesting you, if you can, you
Yes.
probably send the document to ICSA and they can, share the content.
Yes, I have shared with the IPSI.
Okay.
Now I will try to connect. Thank you. I'm requesting to the ICSI IPA, please share my PPT. Have you got the PPT?
Yes, ma'am.
Yes, yes. Thank you
Is
so
it
much.
okay?
No, no, this is not so. This is not so. I'm just sharing. them. This is not, sir.
Is this one?
Sir, I think wrong PPT have shared with you. Just sharing. I have shared the PPT again on email. Please check ICSI IPA. Kindly share the
Please, ma'am, give me a moment.
Have you got?
No, ma'am, I still not got the mail.
Anjali, I have sent to the Anjali Gupta. And all three emails for a Halder is also there.
Is this one?
Yes, yes. Thank you so much. Yes, please. So, the topic is sorry for the inconvenience. There is so much of inconvenience from my side due to the network issue. So, sorry to all the participants and ICSI IPA again. So we'll start without any delay. The name of the topic is Personal Guarantor Liabilities, Insight from the Landmark Judgments. So before going to start the main topic, we should understand what is the IBC and how IBC was come into force. So please show the second slide, the third slide. Kindly show the third slide. The brief history of the insolvency and bankruptcy law. Next, yes.
ICICI, sorry for
yeah.
interruption, ma'am. Can you,
Yes.
the size is so small actually. I don't know about other participants. I cannot see actually. The size of the screen is very small.
Okay,
Yeah,
okay.
now it is fine. Yes.
Okay. Now, is it fine?
Yes, ma'am.
So,
Now it is.
what is the background of IBC? As you all are professionals, you have a very good knowledge on IBC. So you all are aware that there are so many acts still there, like Companies Act, SIC Industrial Companies, Special Provision Acts. There are some of the like liquidation is provided in as per the Companies Act 2013 before introducing the IBC liquidation. So there are some of kind we can say the way out has been provided in these acts. But however, there is a need of IBC. Why is the need to provide a time constraint insolvency resolution professional, means insolvency process is the IDP is we can take it into the time bound in a time bound manner. We can provide the resolution. There is a need to new act, which is the IDP. So the act was passed by the Lok Sabha and by Rajya Sabha. And then Mr. Pranab Mukherjee was elected at that time. There consent on this act and it comes in the course of 20 there are some early cases. The first case was decided by the NCLT. The name of the case is the and the first case which was decided by the Supreme Court is the Innovative Industries Limited and ICICI Bank. So these are the acts which was basically these acts.
Excuse me, ma'am.
These cases, yeah, these cases.
Ma'am, your voice is not clear. There's a background noise.
Sir, there is no background. I'm alone in my office, so I don't think how the voice is coming. Am I?
Maybe it's a network
Please
issue.
mute. Yeah, yeah. Please mute all participants. Kindly mute their mic. I'm requesting to all the participants kindly mute their mic so voice can be clear. So in NCLT, the case was first case was the Synergies Dure Automotive Limited, and the case which was passed in the Supreme Court, the name of the case Innovative Industries versus ICICI case. These are the first case which was admitted in NCLT as well as in the Supreme Court. Now some acts was repealed after come into force of IBC. As you all are aware, you are professionals. So these some acts was repealed and some acts. The next slide, please go on to the next slide. There is some act was repealed. ICSI, IPA. I'm requesting please go on the next slide. Yeah, yeah. So these are the repealed acts, and these are some acts in which the amendments was made. So there are some more acts are also there in which the amendments was made, but I was not mentioned in this slide. Now go to the next slide. Yeah. So in this slide, we will see how the IBC is applicable and how many parts in which it is divided. So there are in total 255 sections which was divided into 5 parts. The first part is the preliminary definition. This is the definition part, and the second part is the insolvency resolution and liquidation of the corporate person part, and the third we are discussing the third part. Today we will discuss the third part. The third part, what is provided in the third part? The insolvency resolution and bankruptcy for the individual and partnership firm. So basically in this part, this is only provided. And part 4 is also there. This is basically the resolution of insolvency professionals, agencies, and the information utilities. And some miscellaneous parts are also there. This is the part 5. And there is total schedule. We can see there is the 11 schedules in the IBC. So basically the IBC is applicable where it is applicable. It is applicable on the corporate entity. It is applicable on the LLPs. It is also applicable on the partnership firm and individuals. However, we can say that the part 3 is not came into force till date. We can say that this part is still there is no individuals and partnerships independently. We can institute any CIRP process in DRT against them. So we can say that this part is wholly is not applicable till the date. So what is the scope of the insolvency? Because if we will say for the insolvency of the CIRP for the corporate person, there is the CIRP process. Pre-packaged for insolvency process is also there. And in the pre-packaged insolvency, you all are aware, there is the minimum, the maximum limit is 10 lakhs has been provided as per the pre-packaged insolvency, and the liquidation process is there, voluntary liquidation is there, and bankruptcy. Bankruptcy in the case of the individual or the partnership firm partners. So bankruptcy is only applicable on those persons. So this is the basic scope and this is the basic structure and applicability of the IBC. Now, what is the framework of the code? So the code is applicable there because there is a regulator. Main regulator is the IBPI who is controlling. Next slide, please show on the next slide. Yeah. The main regulator is the IBBI who is controlling, and the IPA is under the IBBI, and under IPA we are registered because we all are aware there is the three IPA, the ICAI IPA, ICSI IPA or ICMAI IPA. So there are the three IPAs and we are registered with them and as an insolvency professionals, and the information utility is also there who has provided the information whenever is required. So this is the basic structure. And who is the adjudicator? Main. The NCLT DRT is the adjudicator. So NCLT when applicable if the case is related to the corporate entities, companies or LLPs, only then the NCLT is applicable. But this is the different in case of the personal guarantor. We will discuss in all cases now. And DRT is for the non-corporate entities, individuals and partnership firms. So how can we say कि the NCLT is the have the jurisdiction for the personal guarantor? So as per section 60, I will explain some sections also. So you can see कि how the NCLT have the jurisdiction in case of the personal guarantor. So next slide, please show the next slide. So, the personal guarantors insolvency. This is the main topic. First, we will discuss when the personal guarantor insolvency come into force. So, this is the Supreme Court judgment. As you all are the professionals and all have the knowledge of the judgment, and you have all read this judgment. So, the name of the judgment is the in the matter of Lalit Kumar Jain versus Union of India. This is very famous judgment of Supreme Court. So what happened in this judgment? In this case, the applicant means Lalit Kumar Jain, who has challenged. What he has challenged? He has challenged the rules and regulations which were framed by the central government and the IBDI. So they have challenged the regulation which was coming into force on 20th November 2019, and he has also challenged the rules which was incorporated by the central government on 15th November 2019. He was challenged before the Supreme Court, and it is that from the plain reading of the provision, it is not possible to save out the limited application of their provision only in relation, because they are saying in this case they are saying because section the part 3 which is we have discussed for the this is the part 3 which we have
There is some
discussed.
issue in your voice, madam.
Sir, I'm trying. I have no idea why the problem is coming. Some other participants also facing the same issue with my voice.
Yes,
Yes,
ma'am.
Yes,
facing issue.
there is a lot of disturbance.
Maybe your mobile frequency is attacking. I don't know.
Yes, ma'am.
Ma'am, some
What?
background noise is coming. Ma'am, your mobile probably could be kept on silent.
Sir, I will try. No, mobile is already on silent mode, sir.
Okay.
Mobile is already on
Disturbing
silent
sound
mode.
is, yeah.
Anyway, sir, अभी तो यही ऑप्शन है मेरे पास.
Yeah.
So
No,
sorry,
unfortunately, it's very
sorry for this.
disturbing. It is so
Sorry for
big
this.
that we are not able to focus on your voice.
Okay, okay. I will try to sit somewhere else. Okay, I will try. 1 minute. Give me a moment. So now my voice is clear.
No, madam.
This background noise is still there. So,
Maybe
ma'am,
The background because
why don't you
yes,
log out and log in again just for a trial, if
yes,
that is okay
yes,
for you?
yes. I will try.
Your voice is clear, but something disturbance in the voice. My voice means some sound is disturbing.
Yeah, maybe network connection
Yeah,
also.
yeah, yeah, yeah.
Probably once again you can log out and log in. Let's see.
So now my voice is clear or not?
Luckily,
Okay,
background noise is not not there now.
your voice is clear, madam, but some unknown voice is coming.
Then I don't know because my office is on the road, on the face of the road. So maybe some
But now
uh,
background noise is not there.
okay, vehicle's voice is not there.
No, background noise is not there. Your voice is okay.
I think that
Okay,
it is
okay.
coming from
Now,
some device voice. It is disturbing some device.
Correct.
Yeah, yes.
Now it
So
is fine anyways.
your voice is clear, but some device is disturbing your voice.
okay. No idea, sir, how it is so disturbances today or the inconvenience. I'm very sorry.
It's still there. Still.
Yeah. So, the Supreme Court judgment. Now, the judgment dated 21st May 2021 in the matter of Lalit Kumar Jain versus UOI. This is the name of the case. And what was held in this case, the validity of the regulations which was issued by the IBBI on personal guarantor was challenged by the applicant in this case. So what held by the Supreme Court in this case? It was held and they are saying ki part 3, because we have seen earlier that the part 3 is not applicable. This the part 3 of insolvency resolution and bankruptcy for individual and partnership firm. This part is not come into force. Okay, so why they have made the regulations and rules for the personal guarantor? So they have challenged before the Supreme Court. These regulations are wholly impermissible in the law and amounts to the unconstitutional usurpation of the legislation power by the executive. So they have stated. Now, what was held by the Supreme Court? It is held that the approval of a resolution plan does not issue fact to discharge a personal guarantor from his liabilities under the contract of guarantee, because they are saying there is some issue is also in this judgment. They have said कि, if the resolution plan has been approved, the personal guarantor was discharged from their liability. So the court has held कि if even if the resolution plan has been approved, still the personal guarantor was not discharged from their liability under the contract of guarantee. So this was held by the Supreme Court, and the release or discharge of the principal borrower from the debt owned by it or its creditor by the involuntary process by operation of law or due to the liquidation or the insolvency proceeding does not absolve the surety, the guarantor of his her liability which arise out of it, because they are saying, the court is saying that this liability which is arise due to his executing agreement of the guarantee, this liability is the independent contract. So we cannot say the personal guarantor have been discharged from his liability after the passing of the approval of the resolution plan. So, foregoing the reason, it was held that the impugned notification is legal and valid, because by notification these regulations and rules have come into force. So the court held that these notifications are legal and valid, and it is also held that the approval of a resolution plan relating to a corporate debtor does not operate so as to discharge the liabilities of the personal guarantor. So the writ petition was dismissed, and there is no cost was imposed on the petitioner. However, this was held by the Supreme Court that these notifications are legal and valid. So this was held. This is the case by which we can say that personal guarantor insolvency was come into effect with the after this judgment only. So now the question is there, who is the personal guarantor? Please show the next slide. What is the personal guarantor? So what is the personal guarantor? Basically, the section 5, subsection 22 of the IBC provides that the personal guarantor means an individual who is surety in a contract of a guarantee to a corporate debtor. So basically, there is a section 5, subsection 22 of IBC in which it is mentioned. Now, what is the liability of the personal guarantor? So the personal guarantor's liability arises when the corporate debtor fails to repay the loan or fulfill the obligations. This is very obvious. When they have failed, then the liability will arise on the personal guarantor to pay this amount. So what is what is the importance of this personal guarantors in IBC? So we can say, if we will see on the face, we can say the creditor confidence will be developed, because there is the two layers. They have the more recovery chances because they have more confidence, because the two layers has been provided. First, they can recover from the corporate debtor, or if corporate debtor have failed, then they can recover from the personal guarantor. So the creditor confidence can be more enhanced. And now the dual proceedings, because if we can say the creditor can institute the proceeding against the corporate debtor as well as the personal guarantor simultaneously for the recovery of their debt. And but there is some limitation. So what is the limitation? If we will see on the point of an individual or a corporate or a personal guarantor, so there is a limitation, because this will discourage the promoters, because they don't want to give any guarantee. If they are the director in a company, they don't want to give any guarantee without considering their liability. So we can say that there is some limitations or deterrence which encouraging the better financial discipline. So we can say that there is a benefit on the point of view of the creditor, but there are some lacuna or some deterrence on behalf of the personal guarantor. So before going to the cases, before explaining the cases, we should know what is the relevant provisions and what is the relevant sections for the personal guarantor. So I will just explain. Please show the next slide. Please show the next slide. ICSI, IPA, please show the next slide. So the part 3, basically the part 3, chapter 1. What is provided in this chapter? The section 78 of the IBC provides for the matter relating to the fresh start process, insolvency and bankruptcy of individuals and partnership firms. So basically section 78 have been provided for this, and in section 78 it is also mentioned. Please read the please read all these sections very carefully, because our cases, whatever the cases I will explain, this is only based on these sections. So please listen carefully and read the sections carefully. Now, what is provided in section 78? The section 78 provides matters relating to the fresh start, insolvency and bankruptcy of individuals and partnership firms, where the amount of the default is less than 1,000 rupees, or the CG, the central government, may by notification provide the minimum amount of default of higher value, which shall not be less more than 1 lakh rupees. So basically
This
this,
must be 1 crore, madam.
no sir, 1 crore for the corporate debtor. This is
This is
I have
corporate guarantor, na corporate guarantor also, I think.
Yes, sir. Yes, sir. By the case, I will explain you. But what is section 78 saying? I'm saying about section. I'm just explaining the section 78. Later on, I will explain the case. In the case, this is provided 1 crore. You are right. But as per section, what is provided in the act? This the section 78 is basically provided that there is the default should not be less than 1,000 rupees, and the higher value is also prescribed, which is 1 lakh rupees. But there are the cases. This section was also challenged in a case. I will explain the case also, sir. In this is held ki 1 crore will be the amount. So I will just explain. First, we read this section. Now, the part 3, chapter 3. What is provided in part 3, chapter 3? Section 94 IBC 2016 provides that a debtor who commit a default may apply either personally or through a resolution professional to the adjudicating authority for initiating the insolvency resolution process by submitting an application. So, specifically in this section have been provided, the either debtor himself can go for the application of to the adjudicating authority. He can file himself or through the resolution professional. So two options is in their hand, either himself or through the RP. Now, section 95, which is provide for a creditor. The creditor may apply either himself or jointly with other creditors. So these two sections, first for the debtor and second for the creditor. So creditor either himself can file the application before the AA, or he can also file the application through the resolution professional. So two options is with them also. So, the creditor may also apply under subsection 1 in relation to any partnership debt owed to him for initiating the insolvency resolution process against any one or more of the person of the firm, or the partners of the firm or the firm. So, he can institute any application against one or more partner or the firm. So this is only depend on their choice or their debt, how the debts was due. Now section 96. What is provided in section 96? Interim moratorium period have been prescribed, because if we will say the corporate CIRP of a corporate person, there is no interim moratorium period have been provided. There is only section 14 which is prescribed for the moratorium period. But in the case of the personal guarantor, there is a interim moratorium period is also there. So where an application is filed, I will also explain a case for this purpose. So please listen the sections carefully. So what is provided in section ki where an application is filed under section 94 or section 95, The interim moratorium shall commence on the date of the application in relation to all the debts and shall release to have effect on the date of the admission of such application. So what is provided in interim moratorium? The interim moratorium shall commence, please read carefully, on the date of the application. When we have filed the application, the interim moratorium is started. Either application admitted or not admitted, doesn't matter. So interim moratorium will start on the date of the filing of your application only. So in relation to all the debts and shall cease to have effect on the date of the admission of such application. And during the interim moratorium period, what happened in the moratorium period? In this moratorium period, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed. The creditors of the debtor shall not initiate any legal action proceeding in respect of any debt. Where application has been made in relation to the firm, the interim moratorium under subsection 1 shall operate against all the partners of the firm as on the date of the application. So this is happened after the interim moratorium have been introduced. Now section 97 provides for the appointment of RP. If suppose if we have filed the application as a debtor in section 94, or if the creditor in section 95, then we can choose our RP. If we have choose our RP at the time of filing the application, then the adjudicating authority shall direct the board means IBBI, within 7 days of the date of this application to confirm that there is no discrepancy proceeding pending against the RP. So this will be directed by the adjudicating authority to the IBBI. Suppose if we have not choose any RP, then the adjudicating authority direct the board within 7 days of filing of the application to nominate a person as a RP in our case. So these are the scenario. Now section 98 is also there for the replacement of RP. Suppose if we have choose as a RP in a matter, but we the debtor and the creditor have the right, have the options for the replacement of the resolution professional. Section 98. Please show the next slide, I think. 98, section 98 is there. Yes, section 98. Please go on the last slide. Yes. So this is the replacement options is also available for the replacement of the RP. Now section 99, what is provided as per section 99? The section provides for the submission of the report. Suppose if we have filed the application for the corporate guarantor insolvency, then the court will then the report have required to be submitted by the resolution professional on this before the adjudicating authority. Only then adjudicating authority will give the approval for the admission of the application or the rejection of the application. So report is mandatory. In this case, the report is mandatory. Suppose if we will talk about the CIRP, normal CIRP of the corporate debtors, there is no report have been asked from the RP. There is only the if we will go for the section 9 petition or section 7 petition, for the section 9 petition, there is only demand notice. First, we have required to serve and then file the application. But if we will discuss for the section 7 petition, we will file all the documents, whatever shown our debt is due, have required to be submitted before the court and the application will be admitted. But in this case, the application can be admitted only when the RP will give the report to the adjudicating authority. Only then the application will be approved or the rejected. Now, where the application has been filed under section 95, the resolution professional may require the debtor to prove the repayment of the debt claimed as unpaid by the creditor by furnishing the evidence of electronic transfer of the unpaid amount in the bank account of the debtor, or the evidence of the encashment of the check issued by the debtor, or the signed acknowledgement by the creditor accepting the receipt of the deed. So basically, if we will file the application under section 95, so we should require to furnish these documents. Now the RP shall give a copy of the report before to the debtor or the creditor as the case may be. So this report copy have required to also be given to the debtor if debtor have filed the application, or creditor if the creditor have filed this application. So please go to the next slide. Please go to the next slide. Yes, the section 100. What is provided as per section 100? The adjudicating authority shall within 40 days from the date of the submission of the report under section 99, that report we have discussed in the above provision, required to file submission of the report, either admit or reject the application as the case may be. So this is on the adjudicating authority, either admit or either reject. Now section 101 of the IBC provides for the moratorium will start, because we have seen the moratorium as per section 14 will start in case of the corporate debtor after admission of application, and the moratorium period is 180 days. So the same has been provided in this also. The 180 days is given, but the 180 days beginning with the date of the admission of the application, or on the date the adjudicating authority passed an order on repayment plan under section 114, whichever is earlier. So this is specifically provided in section 101 of the IBC. Now section 102 is also provide that the adjudicating authority shall issue a public notice, because if we will discuss about the CIRP, the corporate debtor CIRP, the public notice, there is the public announcement have required to be made within 3 days after admission of the application. But in this case, there is a public notice within 7 days of passing of the order under section 100, means admission or rejection of admission of the application, invite the claim. Now the means this is not the responsibility of RP to issue a public notice. This is in this case, this is the responsibility of adjudicating authority to issue a public notice within 7 days of passing of the order under section 100, inviting the claim from all the creditors within 21 days of such issue. So within 21 days, we have required to submit our claim if there is any claim before the RP. So the notice shall be published in at least one English or vernacular newspaper which is in circulation in the state where the debtor resides, or affix on the premises. This is very important. Affix on the premises of the adjudicating authority and placed on the website of the adjudicating authority. However, if we will speak about the CIRP of the corporate debtor, there is no such publication, no such placement have been required to be made on the adjudicating authority website or the premises of the adjudicating authority. But in the case of the personal guarantor, the public notice was issued by the adjudicating authority, and this will be affixed on the premises of the adjudicating authority, and this will also be placed on the website of the adjudicating authority. So this is important. Now, what is section 103 have provided? The section 103 is provided for the submission of the claim. So the claim have required to be submitted. The creditor shall register the claim with the RP by sending the details of the claim by electronic communication or through the courier speed post. Now, the RP will prepare the list of RP. Next slide, please show the next slide. So 103 is there for the for provides for the registration of claim by the creditor. So the creditor will register their claims before the RP, and RP will prepare the list as per section 104. They have prepared the list of the claim, whatever the claim was submitted by the creditors on the basis of the application filed as per section 94, 95. And section 105 provides for the repayment plan. मान लो means the repayment plan is like the resolution plan. If we will discuss about the corporate debt, the CIRP of a corporate debtor, then there is a resolution plan. But in case of the personal guarantor, there is a repayment plan. So the debtor shall prepare in consultation with the resolution professional a repayment plan containing the proposal to the creditor for restructuring of his debt. So in this case, they have prepared this repayment plan themselves. But if we will say for the corporate, the insolvency of the corporate debtor, the other persons have prepared the resolution plan for them, and they have submitted the plan in the company. But in this case, they have prepared, the debtor have prepared the plan, the repayment plan, and with the consultation with the RP, and submitted before and take the proposal from the creditor for restructuring their debt. So now section 106 also provides for the report of the RP on the resolution plan. So what will say? The RP will provide the report on the resolution plan. The RP shall submit a repayment plan as per section 105 along with his report on the plan to the adjudicating authority ki how this is very beneficial to the creditors. And so they have submit to the adjudicating authority within a period of 21 days from the date of the submission of the claim. So the time period is also mentioned in how much time, in which time they have required to be submitted. Now section 101 is also important, provides for the approval of the repayment plan by the creditor. So 3/4 value, because in this case we have required, how much voting we have required? The 3/4 value of the creditor present in person or proxy and voting on the resolution. But if we will discuss as per the corporate person insolvency, there is the 66% we have required the vote. But in this case, we have required 75%. Basically, 3/4 means 75% voting we have required. So this is all important section. Now, I will discuss some regulations, some important regulations. Please show the next slide. So what is provided in the regulations? Regulations 19 of the IBC. 1 minute. Regulation 4. Regulation 4 of a personal guarantor regulation provides that the insolvency person other than who has filed the application under section 94, 95 on behalf of the guarantor creditor has provided a written consent. So if we are appointed in a case as a personal guarantor case, we have assigned a case, then we have required to provide our consent in form A to the adjudicating authority before his appointment as the RP in the resolution process. Now we have required to take the claim. So claim, there is only one form. There is only form B. One form for the claim has been provided. This is the name of the form is form B only. When we will discuss about the corporate debtor insolvency, there are so many forms like form B, form C, form D, form E. But there is only one form. Form name is form B is only prescribed for the submission of the claim by the creditors. So the creditor shall submit, regulation 7 provide this, the creditor shall submit its claim along with the proof to the resolution professional in form B on or before the last date mentioned in the public notice issued under section 102 subsection 1. So This is also provided. Now, Regulation 11 provides that the creditor who is included in the list of creditors shall be entitled to participate in the meeting of the creditors. So, who is in the list of creditors can participate in the meeting of the creditors. The resolution professionals shall convene the first meeting of creditor in accordance with subsection 1 of section 107 and shall convene the meeting by giving such notice to other participants as decided by the creditor, not less than 48 hours, because 48 hours or 24 hours, these time limit have also been provided in the regulations of the corporate debtor insolvency. The 5 days notice we have required to give. So this is also provided here. The resolution professional shall convene a meeting of creditor on a request by the creditor having the 33% of the voting. The same is here. The 33% voting we have required when we conduct the voting in the corporate debtor insolvency. So this is the same here. Now go to the next slide, please. The regulations 19. Please go to the next slide. ICSI IPA, please go to the next slide. Yes. So the regulations 19 provides that the resolution professional shall file the repayment plan as approved by the creditors along with the report mentioned in section 106 or 1012. So 106 we have already discussed. See what is in 106. 106 report have required to be provided on the resolution plan, and what is 112? 112 is there where we have suppose if we have conducted a meeting of the creditors and they have given some other suggestions, then the 112 is applicable. So we have required to submit the repayment plan as a RP before the adjudicating authority on or before the completion of the 120 days. So please consider 120 days. Total time, how much time is given? 180 days is total resolution plan was, resolution time has been given for the personal guarantor insolvency. But we have required to submit our report within 120 days. So point to be noted, within 120 days, we have required to submit our report. The resolution professionals shall provide the copies of the documents filed with the adjudicating authority under sub-regulation 1 to the guarantor and the creditor within the 3 days from the date of such filing. So they have served the copy, whatever the document they have filed, to the creditors and others. The regulation 22 provides that in event of non-cooperation of the guarantor, suppose if they have not cooperated, sometimes we have seen in corporate insolvency also, the directors are not supporting, the staff are not supporting, then we have filed the application as per section 19 subsection 2 or 1. But in this case, suppose if the corporate if the guarantor is not, personal guarantor was not supporting or was not cooperating, then we can also proceed against him. Regulation 22, which is specifically provides for the if the in the event of non-cooperation of the guarantor at the time during the resolution process period or during the implementation of resolution plan, the resolution professional shall prepare a statement to this effect and file the same with the adjudicating authority for appropriate direction. So specifically provided in this regulation also. Now we will discuss the cases. So actually we have read all the provisions, all sections. Now sections and regulations are clear. I think now we can understand the judgment clearly. So please show the next slide. So the first judgment I have explained. The judgment name is the Mahinder Kumar Agarwal versus ETC India Financial Services Limited. This is the first respondent, and Devrat Rana, this is the second respondent, and held on when the order was passed in this judgment, the 1st August 2023. So what happened in this case? Actually, the the applicant, Mr. Mahinder Kumar Agarwal. In this case, the applicant is the Mahinder Kumar Agarwal. He is saying the tribunal have no jurisdiction to try this company petition. The Mahinder Kumar was saying the tribunal has no jurisdiction to try this company petition admitted the petition under section 95 of the IUC and appointed the second respondent as a resolution professional. They are saying कि NCLT have because NCLT Hyderabad bench is there who has passed the order against the Mahinder Kumar Agarwal, who is the personal guarantor. So they are submitted कि this is not the tribunal is not having the jurisdiction. As you all have read, I was also read at the time of my examination. For the corporate, if we will see the insolvency of a corporate person, there is the NCLT have the jurisdiction. But for the insolvency of an individual or the partnership firm, the DRT have the jurisdiction. So they have submitted कि NCLT have no jurisdiction to entertain this kind of application because personal guarantor is the individual person. They have saying. So what held in this case, it is the version of first respondent, the financial creditor of the tribunal has jurisdiction to entertain the insolvency proceeding against the personal guarantor even when the CIRP proceedings are not pending against the corporate debtor. They have also said because there is no CIRP proceeding was instituted against this company, the name of company you can see, Messrs. Gati Infrastructure Bhasmi Power Private Limited. This is the company in which this person, Mahinder Kumar Agarwal, is the director or something, is the personal guarantor basically in on behalf of this company only. So they have said कि this is the personal they have said कि because no CIRP proceeding instituted against the corporate debtor, so the tribunal have no jurisdiction to entertain any insolvency proceedings against the corporate guarantor, personal guarantor. So what was held here is the learned the council of the first respondent. First respondent means the company name. The PTC India Financial Limited Services Limited. The first respondent council have submitted what submitted. They have referred the section 128 of the Indian Contract Act. What is provided in this act? In this section, they are saying that the guarantor's liability is coextensive with that of the principal debtor. So they have the coextensive guarantees with each other, and that the personal guarantor is in the instant case clearly mentions that the guarantee is an independent obligations of the guarantor, and on 8th 8th March 2019, the personal guarantee was invoked on behalf of the lenders, including the first respondent. So they have submitted this provision also before the court. Please go to the next slide.
Ma'am, shall we ask you questions in between or
No, sir. After
Sure,
I will after the completion of presentation, we will
Okay.
discuss. So they have said this. Now the next slide. Please show the next slide. ICSI IBA and requested. Please show the next slide. Yes. What happened? They have also submitted, the first respondent council also submitted a case. Case name is the Rohit Nath versus KEB Hana Bank Limited, in which they have said issue was whether the insolvency proceeding against the personal guarantor as initiated by the creditor before the DRT can be dismissed. So in this case, what was happened? They have instituted a CIRP proceeding against the personal guarantor before the DRT, but the DRT have dismissed because they have said it was held that the liability of the personal guarantor and corporate debtor are coextensive. and the guarantor cannot be permitted to escape its liability solely on the premise that no proceeding were initiated against the corporate debtor. So first of all, 2-3 things we have cleared from this judgment. I will discuss after this. So what was held by the NCLAT? NCLAT said that the tribunal, keeping in mind the respective contentions advanced on the either side and considering the facts and circumstances of this case, come to the resulting conclusion that the adjudicating authority and the tribunal has the jurisdiction to entertain or initiate the CIRP even when no CIRP proceeding is pending against the corporate debtor. And in any event, the corporate insolvency process proceeding is pending and continues to be pending against the corporate debtor. So it was held whether any proceeding against the corporate debtor was instituted, whether they are pending or not pending, still the creditors have the right to institute any suit, to file any application against the personal guarantor to the NCLT, not the DRT, to the NCLT only. The DRT have not the jurisdiction. The NCLT have the jurisdiction to take up the cases against the personal guarantor. So this was held, and in any event, the corporate insolvency resolution process proceeding is pending and continue to be pending against the corporate debtor. Viewed in the perspective order, this case passed by the adjudicating authority this order is admitted. Whatever the passed by the adjudicating authority, the NCLT bench Hyderabad. So the appeal was failed basically in this case. Now we will discuss the second case. Please show the next slide. Now the case name is State Bank of India versus Gauri Shankar Poddar and this Geeta Maheshwari. So Gauri Shankar is Poddar is the personal guarantor basically in this case, and Veena Maheshwari is the RP, resolution professional for the Raj Rayon Industries Limited. This is the corporate debtor basically in this case. So there is two appeals. Please listen this case carefully because very interesting case. There is two appeal in this case because first appeal on behalf of the State Bank of India before the NCLAT what against the order of the adjudicating authority, against the order of the NCLT. Why? Why the appeal is there? On the ground that the guarantee were either unenforceable or time barred, because the NCLT gives the direction that the guarantee which was provided by the personal guarantor, it is unenforceable and is a time barred guarantee. They have held this. So the State Bank of India have filed their application before the NCLAT. And the second appeal was filed by the Vidita Maheshwari, RP. RP have filed this appeal. Why filed this appeal? Because NCLT have also given the direction that the conduct of the applicant means resolution professional need to be inquired by the IBBI. They have given this direction. IBBI required to inquire the conduct of the RP. So there is a two appeal in this case basically. So what was held in the matter of State Bank of India versus Gauri Shankar Poddar and in this case in 1999. What happened? Raj Rayon Industries Limited. There is a company, the name is the Raj Rayon Industries Limited, the corporate debtor who has availed the financial assistance. Please go to the next slide. Please go to the next slide. Please, ICSI IPA, go to the next slide. Yes, yes. Thank you so much. So, what happened in this case? In 1999, the Raj Rayon Industries Limited, this is the corporate debtor
who has availed the financial assistance from the SBI, State Bank of India. They have taken the loan in 1999. Please remember the dates because dates are very important in this case. These loans were secured through an agreement which was executed on 6th December 2005. So the loan agreement was executed in 2005. Okay. Now there are several amendments in this loan agreement was made. 26th February 2007, there is a first supplemental working capital consortium agreement was entered, and first supplemental joint deed of hypothecation was executed. Now in 28th December 2007, again a second supplemental agreement was entered. Now in 2010, again third supplemental agreement was executed. In 11, fourth supplemental agreement was executed. In 13, the Gauri Shankar Poddar is the director of the company who has executed a deed of guarantee in favor of SBI for securing the loan of amount of 292 crore. So they have given the guarantee. The Gauri Shankar Poddar is the personal guarantor who is also the director of the company. He has given the guarantee in 10th July 2013. Please note the date. Now, what happened? Please show the next slide. Oh, sorry. Yes. Sorry. The default was started in the company, and the company accounts was NPA on 30/11/2013. The company account was become NPA. Now the account was classified as a NPA on 30/11/2013. So what happened in this case? The Mr. Gauri Shankar submitted their resignation. His resignation he has submitted on 6th March 2014. Means after the account of company become NPA, he has submitted his resignation on 6th March 2014. This resignation was formally accepted by the corporate debtor on 18th March 2014. So the resignation was also accepted by the CD. Now, what happened? The seventh supplemental working capital consortium agreement was again executed for increasing the limit of 290 crores because he was provided the guarantee for 292 crores. But after that, one more supplementary working consortium agreement was executed, and now the limit has been increased from 192 crores to 398 crores on 25th 7 yani 25th July 2014 after his resignation. So please note the date and keep in mind the dates. Dates are very important in this case. The sanction renewal letter dated 19th January 2015 further extended the loan facilities. A revival letter was also executed on 6th February 2016 and acknowledged the outstanding liabilities of the letter. Also refers 13 and 2014 guarantees, reaffirming their validity and applicability. The SBI issued a recall notice. Now, after these all letters and they have admitted the loan, now SBI issue a recall notice to the corporate debtor and its guarantor, including Mr. Gauri Shankar Poddar on 18th January 2018. The notice demanded payment of 998.52 crores. The SBI issued the notice. Now on 8th March 2021, the SBI issue a demand notice to the Gauri Shankar Poddar under Rule 7 subsection 1 of the insolvency rule. The notice sought payment of this amount and inclusive of interest and was issued in compliance with the procedural requirement of the code. So this was, please show the next slide. So now adjudicating authority dismissed the SBI application as per section 95 because they have filed their petition for the revocation by alleging the revocation of guarantee by Mr. Gauri Shankar Poddar and further invocation of the guarantee being time barred. This was held by the NCLT ki this guarantee is time barred. But I will say that this is not time barred. How this is not time barred, I will just explain. The counsel for the appellant submits that the guarantee executed by the respondent on 10/7/2013 because they have executed loan guarantee. I have seen you the in the slides that the corporate debtor, the personal guarantor have given the guarantee on 10th July 2013 and reaffirmed this guarantee on 29th March 2014 after he has resigned from his post as a director. However, he has reaffirmed these liabilities as an independent and irrevocable contract. He was reaffirmed this guarantee. Now there is a three issues involved in this matter. Ki whether the revocation of guarantee by the personal guarantor is valid, whether the changes in terms of conditions of the guarantee agreement would be lead to be novation, or whether the CIRP proceeding against the guarantor are maintainable on the ground of limitation. So there are the three questions, three issues have arisen before the NCLT. So what is the answer of first question? Ki whether the revocation of guarantee by personal guarantor is valid. So there is an answer. It is seen that the respondent number 1 had signed second personal guarantee document on 29th March 2014 after his resignation was accepted by the board. Subsequently, he had written a letter in 2014. He has also given the letter in 1st April 2014 to the financial creditor seeking the use of guarantee. But the adjudicating authority decided कि as per section 130 कि he is not liable for the future contracts. But because the guarantee agreement, whatever is provided in the guarantee agreement, this is provided कि this is the continuous guarantee. The word has been provided the continuous guarantee. So what was held by the NCLT ki we know that the guarantee is a show the next slide. Please show the next slide. ICSI IPA, please show the next slide. Yes. So what is we note because this was held by the NCLT ki we note that the guarantee is evident from clause because there are some clauses is provided in the guarantee agreement. The clause 2, 8, 11, 12 of the guarantee clause was provided there. So they have said he intended to be irrevocable and continuous in nature because the guarantee which was provided, the terms is the continuous in nature. The guarantee is the continuous in nature. So therefore the respondent number 1 does not absolve him from his obligations under the guarantee agreement as a financial creditor and has not agreed to such revocation. The terms of the contract agreement also clearly shows that the contracts are irrevocable because there is a continuous guarantee was provided as per the agreement. So before giving any guarantee as a personal guarantor, you should check if anybody have given any guarantee in any case. Please check the terms and conditions of the guarantee agreement properly, whether this is the continuous nature guarantee or not. So in this case, the clauses has been provided for the continuous guarantee in nature. So it was held the terms of the contract agreement, the contract is irrevocable guarantee contract. Now we will discuss the second question. What was the second question? Second question is there ki whether the changes in terms of the condition of guarantee, if any, lead to a novation. Novation is amendment explaining phase. So we have gone through the relevant clauses because some clauses is also provided in 2013 agreement. So this is clearly state that the respondent number one would not be discharged of his liability even if there is any variation in the terms of the contract, because this clause was provided. So it is very clearly show the court held the respondent number one will not be discharged of his liability. Means Gauri Shankar Gupta cannot be discharged from his liability even if there is any variation in the terms of the contract or security document. So hence that we hold that the liability of respondent number one is due and subsequent amendment if any to the agreement to the extent are beneficial for the respondent number one would continue to be liable for the outstanding amount. So this was meant by the NCLAT. Now question number 3. Whether the CIRP proceeding against the guarantor are maintainable on the ground of limitation, because the adjudicating authority have dismissed the application on the ground of time barred application. But what was held by the NCLAT in this case? The last issue is related to the limitation in filing of the CIRP petition. The appellant invoked the guarantee by notice dated 18/1/2018 against the guarantor for making the repayment, the payment of 998 crores, including the interest. Applicant filed the application on, please see the date, application on 24th March 2021. Filed this section 95 application. So the notice applicant invoked the guarantee in 2018, but filed the application in 24th March 2021. So show the next slide, please. ICSI IPA, please show the next slide. ICSI IPA, please show the next slide. Yes. So what was held in this? The answer number 3 is there. The last transaction in the account which was executed in 2017, and therefore the adjudicating authority held that that was filed well within the statutory period of limitation of 3 years from the date of the last transaction before 2020. The adjudicating authority was saying because the last transaction was executed in 2017, so you should require to file this application in 2020 only. But what was held by NCLAT ki guarantee specifically state that the guarantee executed shall be a continue one, because in guarantee agreement this is provided, this is the continue guarantee, and shall remain in force until the amount owned by the creditor remain unpaid. So this guarantee is continue. The guarantor issued the demand notice after the CIRP against the CD was admitted in 2020. So this means that the concerned court has acknowledged the debt. Therefore, the specific demand notice in terms of section this was well within the time period. And we further noted that the period of limitation against the guarantor shall start only when the demand is raised from the guarantor specifically. So when the time period of limitation will be start in case of guarantor, this will be start only when the demand is raised from the guarantor specifically. So this was held by the NCLAT, and in case of continued payment by the principal borrower, no demand would be raised against a guarantor, and thus limitation does not come in. So since the last date of filing in the present case fall within the COVID period, there is also the COVID period, because in 2021 we have filed. So in 2020 there was the COVID period. So COVID exemptions period are also there. On the basis of our finding or the issue frame, we hold that the contention of the appellant as merit because SBI have the merit in this case, and the adjudicating the NCLT held that the adjudicating authority has failed to comprehensively deal with the issue because there is no time limitations, because this is the continue guarantee as per the agreement, and there is also one fact is there ki the guarantor limitations will be start only when the demand is raised from the guarantor specifically. In this case, the current notice or demand notice was issued in 2018. So and after they have not paid their claim, they have not paid their dues only then, because this is the continue guarantee. So this will start only when the demand is raised from the guarantor specifically. So this was held by the NCLT. Now we will discuss the second appeal because there are the two appeals in this case. First, we have discussed the appeal on behalf of the State Bank. Now we will discuss the second appeal which was filed by the RP. Vinita Maheshwari have also filed the appeal because the NCLT have given the direction that she is required to required the inquiry of her conduct by the IBPI. So what was held in the second appeal? Please show the next slide, please. ICSI IPA, please show the next slide. So what was held in the second appeal? ICSI IPA, please show the next slide. So what was held in this? The appellant submits that the application, that the principle in this case, in this second appeal, the appellant submits that the principle of natural justice was not followed by the adjudicating authority because he has passed the order without giving any opportunity or without taking any explanation from the applicant. So he has submitted before the court and without giving any hearing chance to the applicant on this issue. So this was also submitted by the Vinita Maheshwari, the RP in this case. So NCLT gives the direction to him. The first appeal is succeeded, is allowed, and the second appeal, all adverse remark against the applicant in the are expelled. It means the second appeal was also allowed, and whatever the direction was given by the NCLT to direct the inquiry from the IBBI, this was not required to be handled in this case because the NCLT was not followed the principle of natural justice. So the both appeals was allowed in this case. Now I will explain the third case also. Please show the next slide. Yes, thank you. So now this is also very important case. The Union Bank of India, I can say the Andhra Bank, and versus Mr. P.K. Balsubramaniam, and State Bank of India. So there is two respondent basically. First is the P.K. Subramaniam and the other is the SBI, and the Union Bank is the applicant in this case. So what happened in this case? Basically, two petitions were filed. Section 95 application. Two applications have been filed in this case. The first application was filed by the Union Bank of India, and the second application was filed by the State Bank of India. So whatever they have did as per section 19, this will be I think this is required to be discussed here. So what was held in this case? The Union Bank have filed the application as per section 95. However, the NCLT was dismissed this application, and he has submitted again. He has gone for the appeal. So this appeal is filed against the order of NCLT, in which it was observed that the application filed under section 95 of IBC seeking initiation of the CIRC as against the P. Balasubramaniam. The application is already been filed against the personal guarantor in this case, and because what happened in this case, there is already an application have been filed against the corporate guarantor in this case, and RP was also appointed as per section 96, and the interim moratorium will commence, hence no application against the same respondent can be filed before any forum. They have submitted, the Union Bank have submitted, because interim moratorium have started. So SBI cannot file any application against the respondent, or for the present application is dismissed by the NCLT, and NCLT have dismissed the application because there is two simultaneously application have been filed. First filed by the Union Bank, and second filed by the State Bank of India. So I will show you some dates also in this application. Union Bank of India was dismissed on the ground that the TP number this filed by the State Bank of India against the same personal guarantor, because against the same personal guarantor both banks have filed the section 95 application. So what was held in this case? Actually, in this case, the appellant that the section 95 application, second slide, please show the second slide. Please show the second slide. ICSI, IPA, please show the second slide. The next slide. Next. So what happened in this case? There is a application under section 95 have been filed on 31st/12/2021. Okay, was assigned a registration number, and because this application was filed by the Union Bank on 31st December 2021, and after that SBI have filed another application on 3rd January 2022, means after 3 days, or after filing the application by Union Bank, the SBI have filed this application. Now the registration number, because after we have filed, when we have filed the application, there is a need to clear all the scrutiny error. Only then we have assigned a registration number by the registry. So this is the process basically. So in this case, Union Bank have filed this application on 31st
Please
December
increase your,
2021. Yes, yes, sir.
please increase the screen. The screen is
Sir,
very
in screen is
small.
with the IPA. So is it visible now?
Yes,
Now,
ma'am.
sir,
It is visible
yes,
now.
okay. So there is two applications in this case was filed. First was filed by the Union Bank on 31st December 2021, and second was filed by the SBI, State Bank of India, on 3rd January 2022, means 3 days, after 3 days he has filed. So, but what happened in this case, the registration and the registration number, which is required to be allotted by the registry, which was given to the SBI first, and later on by the to the Union Bank, because the registry have granted the registration number on 12 January 2022 to the SBI, but on 9 February 2022 to the Union Bank, because you all are aware, when we have issued the registration number, only then our matter will be listed. Okay. So in this case, however, the application first filed by the Union Bank, but registry was given the registration number only after clearing of all scrutiny error on 9th February 2022, the date which is after the SBI registration number. So SBI have got the registration number on 12th January 2022. Within 10 days, he has got this registration number. However, Union Bank have got this registration after 1 month. The case was listed for hearing on 4th March 2022, April 2022, May 22. These are the hearing dates. However, one mistake also made by the Union Bank, the Union Bank was not submitted कि they have not submitted कि they have filed their application first and they never got to the notice to the bench that another application was also filed by the SBI. They have never shown this fact before the court. So in this case, what was held, the NCLT held कि if both the bank have filed the application, but when you will submit your claim, suppose if I'm a SBI, I have filed the application as per section 95, but Union Bank have the right to submit their claim as per section 103 of the code. So there is no prejudice will be caused to the applicant hearing. So the same was held by the NCLT. This was held by the NCLT. And the same was held by the NCLT कि thus when an insolvency resolution process commences against the personal guarantor, all creditors of the personal guarantor are taken care of in the proceeding under chapter 3. The court does not contemplate the multiplicity of the application against the same personal guarantor. So this is the point to be noted. There is no multiplicity of applications can be proceeded before the court. If one petition was admitted, the other creditors can submit their claim before the RP. So there is no need to file the multiple applications before the court. So this was admitted by the NCLT in this case. Now, please show the next slide. So, keeping in view of the order of admission has not yet been passed by the, because admission order was still not passed by the adjudicating authority, and also there is that no prejudice will be caused to the applicant herein, so they can file their claim. Basically, they have said that they can file their claim with the RP, and also having regard to the fact they were given liberty in accordance with the law by the adjudicating authority. So, this appeal was dismissed. So this was held in this case. So basically what we have done here, there is no need to file the simultaneously two petitions against the same corporate, same personal guarantor, because if one bank have already initiated the actions against him, then the others have required to file their claim before the RP only. So we have learned from this case here. Now, please show the next slide, ICSI IPA. Please show the next slide. So, this is the case of Suresh Kumar and Mr. Raj Kumar versus Central Bank of India. This is also very interesting case held on 27th November 2024. Basically, very recent case is this. So, what was held in this case? That this appeal has been filed by the Suresh Kumar, and the Raj Kumar is the applicant, and against the Central Bank of India. So in this case, the adjudicating authority, Chandigarh bench, filed by the Central Bank of India, responded herein, has been allowed directing the reconstitution of committee of creditors. They have directed you have required to reconstitute the committee of creditors by excluding the appellant herein, aggrieved by this order, because NCLT Chandigarh have given the direction these these persons, because they are the personal guarantor, they are not covered in the committee of creditors. So please exclude these applicants. So they have come for the appeal here. So what was held in this case, agreed by the order dated this appeal has been filed. The CIRP against the corporate debtor, measures Ram Hari of the private limited company was commenced on an application filed by the OC by order dated 14 February 2020. So in 2020, the proceeding was started, and Central Bank of India conveyed कि he is having the voting right of 51.37%. It was conveyed by the Central Bank of India in this case. So the RP wide email dated. Now RP have sent an email on 8 June 2020, because admitted in February, and RP have sent the email in June 2020. Sent a report on the constitution of COC by adding 2 more members. They have said, "Ki please add these 2 more unsecured financial creditors who had given the personal guarantee to the applicant bank to secure the loan taken by the corporate debtor, namely Suresh Kumar and the Rajesh Kumar, who are the applicant in this appeal." So they have sent the mail, sent a report on the reconstitution of the company of COC. The claim of the appellant were admitted on the basis of recovery certificate, which was issued by the DRT in Chandigarh, originally filed by the Central Bank of India. So they have submitted this certificate and said ki reconstitute the COC. Now please show the second slide, the next slide, ICSI IPA. Yeah. Thanks. So what happened? Ki it is submitted by the bank that the claim of the Central Bank of India allocated 51.37%. Or suppose if they have admit the claim of the above applicant on the basis of personal guarantee, then the voting shares of the central bank will be reduced, and this will be reduced as a 26.2%. Now, if this will be this will happen. So whether the applicants are the financial creditor of the corporate debtor, and they are entitled to be part of the COC as has been allowed by the RP, this inclusion has been satisfied by the adjudicating authority in this case. So adjudicating authority have satisfied this reconstitution of COC. What was held by the NCLT in this case? We are of the view that the personal guarantor who have not made any payment in discharge of their guarantee given to the Central Bank of India cannot be accepted as a financial creditor of the corporate debtor, nor any voting shares can be allocated to them in the CIRP of the corporate debtor. So it was held by the NCLT that they have not considered as a SC because there is no payment has been made for the discharge of their guarantee, and it is also submitted counsel of the for the appellant. They have that in view of the matter, the appellant's claim can be treated as a contingent claim. They have submitted that this claim required to be treated as contingent claim. So NCLT said that we only observe that in event of any amount is recovered from the applicant before the close of the CIRP, it is always open to the applicant to bring such material before the RP, because RP have required to consider whether the claim is contingent or not. So we will not say anything on this before the COC, or COC will take the decision on this. So whether the claim is contingent or not contingent, we will not. The NCLT will not give any direction on this. However, it was held by the NCLT that the personal guarantor not paid any amount, so they will not be accepted as a financial creditor of the corporate debtor, and they have not the voting right to give any vote in the CIRP process. So this was held by the NCLT. Please show the next slide. Thank you. This is the next case of NCLT. So this was held on 29th July 2022. However, this is also a very relevant case, so I will cover this. The appeal on the ground of Section 95 application admitted by the adjudicating authority. Shri Mukherjee submit that the adjudicating authority commit an error in admitting this appeal because the NCLT have not the jurisdiction to entertain the appeal against the person because because very interesting in this case the personal guarantor have taken the citizenship of the Singapore. In this case, what happened? The personal guarantor have taken the citizenship from of the Singapore. When taken with effect from 18/6/2018. Please note it 18/6/2018. This is date, very important date. He has taken the citizenship of the Singapore. Now he is saying the NCLT in India is not having the jurisdiction to take any action against him because he is not residing in India now. So it is submitted that the applicant being a citizen of Singapore of a foreign nation, the I and B code is not applicable. He is saying the I and B means IBC code is applicable only on those personal guarantor who are the Indian citizen and the foreign citizen are not come into the ambit of the personal guarantor. He has submitted. So what happened in this case? And further, it is also submitted. The intent of legislature has been clearly by section 234 and 235 of the code, which state that the code to be enforced outside India only when the central government enter into an agreement with the government of any country outside India. So they have also submitted here these facts also. There is no agreement of the central government with the government of Singapore. So they have no right to initiate any CIRP process against this applicant because he has taken the citizenship of the Singapore. So this was submitted by the personal guarantor. Now, what happened? The adjudicating authority has acted beyond the scope of the code and its action of admission of section 95 is ultra virus. He is submitted ki NCLT has acted beyond the scope of the code and admission of this application is ultra virus. It is submitted that the applicant is fully bound by the deed of guarantee. Please see the deed of guarantee when was executed in 2015, 19 October 2015, last line, the deed of guarantee was executed. However, when he has got the citizenship of Singapore in 2018, he was got the citizenship of Singapore. So the deed of guarantee was executed in 2015, given by him. The fact and subsequently the appellant was obtained the citizenship of the Singapore is inconstitutional. So this was also submitted. Please show the second slide, the next slide. ICSI IPA, please show the next slide. ICSI IPA, please show the next slide. Yes. So this is very important to be noted कि deed was executed in 2015 but he has taken the citizenship in 2018. So what was held? We have noted that the appellant who was the director of the corporate debtor of this company in 2015, the address of guarantee deed of the applicant was related to the Mumbai because in the address in the guarantee agreement address of appellant was showing that he is residing in Mumbai. The address was also mentioned there. So the respondent further shall issue a recall notice because on 5th March 2018 he has given the respondent issued the recall notice to him in respect of the loan given to the corporate debtor. So the appellant claims to have been acquired the citizenship in So therefore, he has taken the citizenship in June 2018. He has taken the citizenship of Singapore. However, the recall notice was issued in March 2018. So please remember these dates because all issues depend on the dates also. So following issue arise in the present appeal. There is some issues is arise in this appeal ki whether the personal guarantor given by the appellant by guarantee deed dated this 19/10/2015 shall extinguish on appellant the personal guarantor acquiring the citizenship of the Singapore with effect from 18/6/2018. So whether the question was arise. So what was held by the NCLAT ki we may allow first notice the relevant provision of section 3 subsection 23 ki whether personal guarantor if he has acquired the citizenship of Singapore will be covered or not. So the what is provided as per section 2 subsection 23 of the code ki person include what is include in the definition of the person word. This is include a person resident outside India or because this provision specifically include the person resident outside India. So definition of expression person is an inclusive definition as the person residing outside India is also covered by this definition. So it was provided, it was held by the NCLAT. The code specifically has been made applicable on the personal guarantor of the corporate debtor. Whosoever may be the personal guarantor of corporate debtor is covered by section 2 subsection E of the code because section 2E what is provided in section 2 subsection E key this is provide personal guarantor to corporate debtor because in this definition nowhere have been mentioned ki personal guarantor is only residing in India will be covered. So the person word if we will see the definition of person. So person include all the person whether reside in India or whether reside outside India. So this is covered and additionally section 2 is also provided for the personal guarantor to corporate debtors. So these two provisions have been covered in this for this answer for the answering this question. Please show the next slide. Now, the second question is there ki whether proceeding under section 95 subsection 1 against the appellant is a personal guarantor could not have been initiated by the State Bank of India before the NCLT Kolkata bench due to the reason that the applicant has obtained the citizen of the Singapore because he has submitted because this is the beyond the jurisdiction of AA. So he is saying ki no proceeding can be instituted against him. Now, what was held by the NCLAT? Ki we have to come on section 60. What is provided in section 60? Please read after over the PPT. Please read all the sections. You can see ki what is provided in this section. However, some I am trying to explain here also some of the sections. So what is provided in section 60 subsection 1? This is provided categorically provides that the adjudicating authority in relation to the insolvency resolution for corporate person including the corporate debtor and personal guarantor shall be the NCLT because earlier I have seen ki some of the issues was there ki they are saying ki there is no jurisdiction of NCLT. However, section 60 subsection 1 specifically provides ki in case of the personal guarantor means corporate debtor as well as the personal guarantor the NCLT have the jurisdiction basically over the places where the registered office of the corporate person is located. So the office of the registered office of the corporate person was located in Mumbai. So and the person who has given the guarantee was earlier located in Mumbai. Now he has taken the citizenship from the Singapore. So we can say ki insolvency process resolution process initiated before the adjudicating authority within the jurisdiction, because the company was situated in Kolkata, is in the jurisdiction of Kolkata. So the registered office of the corporate person is located, hence the adjudicating authority have the territorial jurisdiction. Registered office of the corporate person is located. So the mere fact is that the appellant now claims to be a citizen of Singapore and has given an address of Singapore is wholly irrelevant for initiating the proceeding against the appellant. So this was held by the NCLAT in this case. Please show the next slide. ICSI IPA, please show the next slide. So the third question is also there, ki whether it was necessary for the central government to enter into an agreement as required under section 234 or 235 of the code, because he has submitted ki there is required to be a agreement between the central government and the Singapore government for adjudicating of this proceeding. So whether there is a need to enter such type of agreement as per which was provided as per section 234 or 235 of the act. So what was held by the NCLAT in this case? The keyword of section 234 of the code is in relation to assets or property of the corporate debtor or debtor, including the personal guarantor of the corporate debtor, as the case may be situated at any place in India or in a country outside India. So there is no such type of questions has been involved in this case. So the applicability of section 234 is only arise when arise where the assets or property of the personal guarantor are situated at any place outside India. In this case, he is only taken the citizenship from the Singapore. Earlier he is residing in India, but now he has taken the citizenship from the Singapore to escape this liability. So this was held by the NCLAT ki we cannot say ki there is a need to take to enter any agreement between the CG and the Singapore government, because we are not taken any possession of the property which is situated outside India. So present is the case where the assets of the personal guarantor as claimed in application under section 95 are not claimed to situate in any place outside India. Present is a case is not a case where the CIRP has been initiated with regard to any of the assets of personal guarantor which are situated outside the country. Hence, the reliance on section 234, 235 are wholly misplaced. So we can say this is only the misplaced of the case. So the appeal, there is no appeal, no merit in this appeal, and appeal was dismissed. So basically what we have learned from this case, we have learned whether the personal guarantor is situated in India or outside India, whether he has taken the citizenship from any country, still he will be can be taken before the adjudicating authority as a guarantor, or the application can be filed against him. So we have learned from this case here. Now we will discuss another case. Please show the next slide. ICSI IGA, please show the next slide. Please show the next slide. This is the case. The NC now I have finished all NCLAT judgment. Now we'll start the NCLT judgment. So this is also important judgment. What was held in this case?
Ma'am, there is one query, if you can.
Yes, yes.
Madam,
Sir,
what is your opinion?
after PPT we can discuss, sir.
Okay,
If you
okay. Thank you. Okay, no
yes,
issue.
yes, sir. Thank you, sir. Thank you so much. Sir, what was held in this case? The name of the case is Apogee Enterprises Private Limited versus late Shri Anil Nanda. Held on 3rd September 2024. What was held in this case? It is the case of the applicant that the applicant has filed Section 95 application for seeking the insolvency proceeding against the personal guarantor. The said company petition is pending. However, during the pendency of the said company petition, the personal guarantor against whom the insolvency proceeding was filed was passed away. In this case, basically, the corporate guarantor have passed away. He is no more. So the question is arise in this application ki whether the application has sought the substitution of the legal heirs. Can legal heirs of the personal guarantor can be taken into the picture, and we can take or we can initiate any action against the legal heirs of the personal guarantor who is not alive, because personal guarantor is not alive, so we can take the action against their legal heirs. So this question was came here. Now, what was held by the NCLT? The issue which arises for our consideration is whether the insolvency proceeding under Part 3, actually we are discussing the Part 3 because the Part 3 is applicable for the personal guarantor. So, under the Part 3 of IBC, abate upon the death of the guarantor, or can the proceeding continue against the legal representative? So, this question was arise here, whether the proceeding as per the IBC will be continued or continued against the legal heirs, or if the personal guarantor is no more alive, then then after the death of the personal guarantor, the proceeding will be stopped. So the question was there. Now, what was held by the principal bench of NCLT in this case? It was held in some of the principal bench of NCLT in all chemist asset reconstruction company case was referred here. In this case, it was held कि it has been rightly pointed out that in case of the proceeding under section 95 of IBC, it is the case for initiation of insolvency resolution process against the personal guarantor, and it is not the case for the recovery of any amount, because that will go contrary to the scheme of IBC. What is provided in the IBC? IBC is provided the resolution also. This is not only the recovery mechanism, because we have heard so many times, we have discussed on this topic so many times कि IBC is not a recovery process. This is the resolution process basically. So if we will say ki we will institute a case against the legal heirs, legal representative of the corporate debtor, so then this will contrary to the scheme of the IBC. In such situation, on a demise of a personal guarantor, an individual who has given his guarantee in favor of the corporate guarantor cannot be instituted. So this was held. Please show they have given some reference of some other cases. Please show the next slide. ICSI APA, please show the next slide. So the question of continuing the proceeding against such a dead person will not arise, because it was held ki such a he is the dead person, so no proceeding shall be arise since proceeding abate as per section 95 has also been closed. In this case, it was held. Now they have submitted the Kolkata bench case, Bank of Baroda versus Divya Jalan case. In this case also held ki, however, there is no provision in the code which envisages that the concept of legal heir steps into the shoes of the deceased personal guarantor. So it was held in this case. Therefore, we hold that the instant application cannot be maintained against the legal heir of personal guarantor under the code. So the council have submitted these cases before the NCLT, and what was held by the NCLT in this case, in view of the above mentioned judgment and the provision of the law, we do not find any merit in this application for substitution of legal representative of deceased personal guarantor in the present proceeding. So what we have learned here from this case, we have learned कि suppose if the personal guarantor was not alive, then legal heirs or legal representative cannot be instituted, any application cannot be instituted against them. So we have learned from this case here. Now please show the next slide. ICSI IPA, please show the next slide. So what was held? This is also a very the sir was saying the question, I think is there here. Here is the answer is also there. The Mudraksh Investfin Private Limited through RP versus Gursev Singh. The judgment is dated 14th November 2024. Because someone have asked in the beginning that the default is related to the 1 crore. I think I have listened a voice. Someone was saying for the personal guarantor, default is required to not be less than 1 crore. So this is true, and this was held by this case. What was held in this case? Whether in such case where the amount of default is less than 1 crore, the personal guarantor can be treated as insolvent and the application under section 95 can be maintained against him. So this was the case. If amount is less than 1 crore, can be treated as insolvent personal guarantor, or section 95 proceeding can be instituted against him. So this question was involved here. Now, Mr. Mohapatra is the counsel of the appellant. Appellant is the Mudraksh Finzer Private Limited through RP or versus Gursev Singh. So what was held in this case? That Mr. Mohapatra had submitted section 78, because section 78 I was reading before you at that time. You have also saying someone said the different amount should be 1 crore, but I was just
Madam, your voice gone.
So I was now the question is here in this case. By this case, I will explain. Because the Mohapatra is same section was submitted. Section 78 he has submitted. He is saying the threshold limit of the default in respect of an individual under part 3 of the code is only rupee 1000, and the present case of default is 10 lakh. So the application is maintainable and deserve to be admitted. He was submitted this. So the section, the definition in these rules, unless the context otherwise required, the adjudicating authority means the purpose of section 60 is the NCLT. This is also submitted. So he has submitted his sections. He has submitted section 60 subsection 1. He has submitted everything, and he is saying the NCLT has the jurisdiction to entertain this application, and the default is less than 1 crore, but 10 lakh is there. But as per section 78, the court have required to admit this application. However, court was not admitted this application. Why not admitted? I will tell you why. What was held by NCLT in this case? With a reference to show the next slide. Please, ICSI, please show the next slide. ICSI IPA, please show the next slide. Yes. So what was held by the NCLT in this case? When a reference to the corporate debtor for the purpose of CIRP is to be made, the same needs to be made with reference to the provision of section 4, and only in such cases where the threshold limit is 1 crore or more, because section 4 has provided for the limit the limit is now 1 crore for the admission of the CIRP against the corporate debtor. So same will be applicable for the personal guarantor also. So this tribunal would have jurisdiction, because the tribunal have the jurisdiction only for the 1 crore. This tribunal have the jurisdiction only for the 1 crore as per section 4. So when a mention to personal guarantor in section 60 of the code is made along with the corporate debtor, we may not read the threshold limit of the personal guarantor, the corporate debtor, different from one which is the mention in the corporate debtor. So whatever the limit is provided for the corporate debtor, the same will be applicable for the personal guarantor. It was admitted by the NCLT in this case. So we cannot say ki 1000 limit which was provided as per section 78 of the code will be applicable in this case. So, because the jurisdiction of NCLT for entertaining any IBC case is only for the 1 crore limit. So, we will, where the amount default is to be paid by the corporate debtor and personal guarantor is less than 1 crore, the proceeding before the adjudicating authority for the purpose of section 7, 9, 10, 94, 95 of the code cannot be maintained. It is very, it is cleared by the NCLT. If any section, suppose section 7, 9, 10, 94, 95, whatever application you want to file, there is required to be a threshold limit of 1 crore only. So personal guarantor, for the personal guarantor, this limit is also applicable. So what was we have done here? In case of personal guarantor, the threshold limit is 1 crore only. Please show the next slide. ICSI IPA, please show the next slide. This is the Supreme Court judgment. I have covered the NCLT judgments. I have covered the NCLT judgments. Now I have covered a Supreme Court judgment on the personal guarantor. So what was held in this case? The case name is the Dilip B. Jivrajka versus Union of India. So the brief text is there. The Dilip B. Jivrajka have challenged. What challenged? The constitutional validity of section 95, the same which was challenged before the Lalit Kumar Jain case, which we have read earlier. The same, they have also challenged the constitutional validity of section 95 to 100 of the IBC. While assenting the merit of the rival submission, we propose to divide the judgment into 3 parts. So the judgment is divided in 3 parts in case, and there is a comparison between the stage of section part 2 and part 3, because part 2 provided for the insolvency of the corporate debtor, but part 3 provided the insolvency of the individual, partnership firm and the personal guarantor. So there is a comparison between these stages. The part 2 comparison is there, part 3 comparison is also there. So the fundamental aspects which needs to be noticed in that part 2 of IBC, on one hand and part 2 on the other hand, deal with the distinct process, because in each part there is a different process have been mentioned. We have already discussed section 94 is there for institution of application. Section 95 is there for if creditor want to institute any application. However, they can only file the application through the RP. Otherwise, they can file the application himself. So there is the different process has been provided as per section, as per part 2 and the part 3 as well as. So because the part 3 is deal with the resolution of individuals and partnership firms only. So this process is different. Now the role of resolution professional, because he is challenging the section now, because he has challenged the section 95 to 100, all sections he was challenged. So court have given answers one by one. So now the role of RP. is also challenged in the corporate as opposed to the individual insolvency. He is saying ki, the RP role is very different in both the process, because part 2, if we will see in part 2, section 16 provided that 16 provided that adjudicating authority have required to appoint the IRP. However, in part 3, if we will discuss part 3, then either RP can file the application as per section 94 with the debtor, or either debtor himself can file the application, or same thing is given in section 95, either creditor himself file the application, or either he can appoint any RP for filing the application. So this is basically provided in this section, so that the applicant has provided that the information and furnish the application which is short under subsection 4, having carried out the process of examination and ascertainment as the specific and relevant information is already provided, the resolution professional may either recommend the acceptance or the rejection of the application by submitting the report, because after submission of the report of the RP, only then court will take the action. The adjudicating authority will take the action, either admit the application or reject the application. So this is only after submitting the report of the RP. However, this process is not as per the part 2. In part 2, there is no such type of process. The creditor directly file the application. TD himself can file the application as per section 10, or the operational creditor can also file the application as per section 9. So, however, there is no requirement of any report by the RP. But in this process, the report of RP has been required. This was also be discussed by the Supreme Court. Now, the salient aspect which emerges from the above analysis, please show the next slide. ICSI IPA, please show the next slide. Yes, thank you. So the salient aspect which emerges from the above analysis is that the resolution professional does not possess an adjudicatory function. We cannot say the RP is having the adjudicatory function, because the last decision is with the NCLT. When he submit the report, only the NCLT will admit the application. Whether he can admit the application, whether he can reject the application. So we cannot say he RP does not possess any adjudicatory function in terms of section 99 in chapter 3 part 3. Now, impact of moratorium, because there is in section 14 is provided as per part 2, but there is two type of interim moratorium provided. Two type of moratorium provided as per part 3. First is the interim moratorium and the other is the normal moratorium. So this was also challenged. The crucial word which were used both in clause B1 or B2 of subsection 1 of 96 are in respect of that. These words indicate that the interim moratorium which is intended to operate by the legislature is primarily in respect of the debt as opposed to the debtor. So, why this interim moratorium has been required here? This is required because required to secure the personal guarantor property before admitting the application. So there is a need to impose an interim moratorium period. However, this is not required as in the process of the CIRP process of the corporate debtor. So it was cleared by the Supreme Court. Please show the next slide. I will show the whole analysis of Supreme Court in this case also. The role of adjudicating authority was also challenged. That part 2 has provided the different role and the part 3 is provided the different role. So the resolution professional submit a report to the adjudicating authority. The report is purely recommendatory in nature, because this is not binding. We cannot say the adjudicating authority is bound by this report. He will take his decision independently either reject the application or either admit the application. So section 100 subsection 1 require the adjudicating authority to pass the order either admitting or rejecting the application within the 14 days from the date of the submission. So these all the constitutional validity have been challenged in this case, basically, and what was held by the Supreme Court. So I will show the Supreme Court analysis. The first analysis is there. No judicial adjudication is involved, because they are saying there is a judicial adjudication is involved at the stage of filing of section 95 to 99 applications. So Supreme Court held that there is no judicial adjudication have been involved here. Please show the next slide. ICSI ITA, please show the next slide. It is also held that the resolution professional appointed as per section 97 serves a facilitating role, because he is serving the facilitating role of collecting all the facts and relevant information of regarding the application. So the insolvency resolution professional, which has been preferred under section 94-95, the report to, because they have required to be submitted their report also, and on the ground, on the report, this report is only recommendatory nature. This is not a binding nature report. So the last decision is with the adjudicating authority. Either they can accept the application or they can reject the application. Now, the submission that the hearing should be conducted by the adjudicating authority for the purpose of determining the judicial facts at the stage when it appoint RT. So is rejected. No such adjudicatory function is contemplated at this stage. It was held by the Supreme Court. So we read in such a requirement that at that stage would be a rewrite the statute, which is impermissible in the exercise of the judicial review. So some of the analysis was made by the Supreme Court in this judgment on the sections whatever provided by the whatever challenged by the applicant. Please show the next slide. ICSI IPF, please show. The resolution profession may exercise the power vested as per section 99 of the ICC for the purpose of examining the application. There is no violation of natural justice because we saying 95 or 90 to the 100 sections are in the violation of natural justice. So Supreme Court held that this is not a violation of natural justice. No judicial determination take place. Adjudicating authority have observed the principle of natural justice in exercise of the judicial jurisdiction under section 100 for the determination whether accept or reject the application. So this is the whole contention was held by the Supreme Court. Please show the next slide. ICSI IPA. The interim moratorium period, whatever provided as per section 96, this is only protect for the debtor from further legal proceeding, and section 95 to 100 is not a unconstitutional provisions, and they do not violate the article 14 and article 21 of the constitution, because they have challenged on these grounds. So Supreme Court is specifically held in this case. So I think I have explained the whole cases, NCLT cases, NCLT cases, and I think PPT is over now. Please show the last page is there. Is there any last page? Yes. So the PPT is end now. So if the participants having any query, they can ask any questions. I'm ready to reply.
Madam, one question is,
Yes.
we are
Yes,
very
sir.
confused. Recently,
sir.
Kolkata bench has held that NCLT is the adjudicating authority in case where initiated, pending or disposed of cases in NCLT are there.
Pending and disposed of cases are there.
against corporate debtor, then
Against
only
corporate
NCLT is
debtor.
the adjudicating authority in personal guarantor cases.
Okay, okay.
Now, today, Anklet Principal Bench has held that even if no pending case or nothing is there, then also NCLT is adjudicating authority.
Okay, sir.
So, what is
But sir, section 60, if we will see section 60, subsection 1, please read after PPT, after discussion is over. It is specifically provided in this section. In case of the cases against the personal guarantor, the NCLT have only the jurisdiction. And
But-
1 crore, and you know the one, if you will go before the DRT, there is the section 78 will be applicable. And there is the limit, is the 1 crore, is the minimum limit has been provided as per the NCLT.
correct.
1 crore is the limit. So how you will initiate the process? So I think as per my understanding or as per my knowledge, sir, if we will take up the section 60 subsection 1, this is the main section in which it specifically mentioned ki the NCLT is having the jurisdiction, and you can give reference of these cases. I will submit the PPT with the ICSI,
Ma'am,
ICA later on.
there is a small confusion there.
Yes.
NCLT, the confusion here is basically many NCLTs have been admitting cases of personal insolvency, even if there is no CERP initiated or pending or
Yes,
closed.
sir.
Yes,
Can be,
but
can be
yeah, but
initiated.
ma'am, one second,
Yes.
let me just complete. But
Yes.
there is a difference in the interpretation here. The thing is now Kolkata bench has come out with a couple of decisions saying that in case section 61, in case of section 60 subsection 1, the correct interpretation will be in case of either initiation, pending, or closed.
Yes.
If these three scenarios are not there,
Mhm.
imagine if there is no CERP initiated or pending or even not closed. In these three situations, that means there is no CERP against the corporate debtor. So that means if there is no CERP against the corporate debtor, the right forum will be DRT as per section 78 and 79.
But sir, the section 78, 79 provision is still not in force
It
because
is,
these
no, if you read the
in the
notification,
yes.
notification, no, I mean circular.
Notification, sir, notification, because this is applicable for the individuals and the when the partnership firm insolvency will be instituted, not the personal guarantor capacity, the proceeding will be instituted. If the application instituted individually in the category of the individual or the partnership firm, only then these sections are applicable.
Ma'am, I would suggest there is a case called State Bank of India versus Nikunj Botra,
Okay.
in which there is a detailed analysis given by circular dated, I think 20th of November 2019.
19, sir.
Personal
But sir, I was also explained a case here, the Hyderabad NCLT. The personal guarantor have submitted कि the NCLT is not having the jurisdiction to entertain his case. But however the NCLT admitted कि the NCLT have the jurisdiction to admit the case of the personal guarantor, even if no pending cases or even if no CIRP proceeding has been instituted against the corporate debtor. So I think, sir,
which
we
case,
should
ma'am? Which
wait.
case is that? Which case is that?
I was explained here, sir. I just
No,
telling
that
you
case,
what.
see, that case also, ma'am, I'll tell you, that is actually, you are talking about Agrawal case.
Yes, Agrawal case.
That
Yes, sir.
Agrawal case, the thing is, at the time of personal
And
info.
this is also very recent case. In 2023, the order was passed, but you are saying the notification which is related to 2019,
No,
sir.
no, ma'am, there is a small
Yes.
correction I would like to, you also
Yeah.
please check. I think in that case also, there was CERP initiated and closed. So what NCLT was saying was, there is nothing pending.
Hmm.
So since CERP was initiated and closed in
Okay.
NCLT, then the PERP will be against personal insolvent, will be in NCLT only.
Okay, okay.
You
Sir,
understood? I mean, there's a slight difference there.
yes. Now I have understood. But
Yeah.
however, I think this is also required to
Yeah, it's
take.
a
This
confusing,
is
it's
the
a tricky
question of
area.
law. Sir, now
It's a
the
tricky
question of law is involved in here. So I think if Supreme Court will pass any order against this, only then I will see ki there is something. And I'm not able to give any answer
Yeah.
on this as of now, as you all are
Correct.
very
A tricky area,
senior.
ma'am. It's a tricky area of
Yes,
interpretation of
yes,
NCLT.
yes. So this is only be decided when some RP will file the application before the NCLT or Supreme Court. Then the decision will came कि the NCLT have the jurisdiction or the DRT have the jurisdiction.
Because see, all these NCLTs have been admitting Section 95 cases based on Mahendra Jajodia's case.
Yes,
Wherein,
sir. Because
NCLT decided that there is no pending CARP required to admit, a case in NCLT for personal insolvency. Mahendra Jajodia was the base for all the admissions of NCLT. But now that interpretation
Sir,
also is
please
sent kind of.
let me know the name of the case. I will also read this case also. What name you have suggested? The name of the case? The Kolkata
I said
bench case?
Mahendra Kumar
No,
Jajodia.
no. Mahendra Kumar Agarwal case I have briefed
No,
here.
Mahendra Kumar Jajodia. There is two cases.
Okay.
One is Jajodia
Okay.
and one is Agarwal.
Okay.
In both these
So,
cases, if you look at very clearly, there were CARPs initiated but closed.
but closed. But there is, yes,
there were resolution
I'm
plans.
asking, sir, I'm asking, is there any case you can suggest me in which the Kolkata bench you have explained earlier,
Yeah,
they
that I
are
am
saying,
saying SBI. Even today,
SBI
SBI
versus.
versus Nikunj Botra.
Okay, I will also see this case.
Sure.
What
Now,
happened in this case?
just now, Anklet,
Yes,
principal
yes,
bench
sir.
headed by Ashok Bhushan and Arun Baroka, they have held that even if nothing is pending in NCLT, this adjudicating authority is NCLT only. Just now,
Kumar sir, which case is that? Any
Okay,
idea
sir.
which case?
The case
Yes.
name, sir? The
just
case name?
just a minute, please. Anklet affirmed the NCLT's jurisdiction over insolvency proceedings against personal guarantors under Section 95. Uh, they have observed that NCLT has power under without being restricted by Section
Sir,
62.
case name. Sir, what is the
They
case name?
are again Company Appeal 2282 and 2283 of 2024.
No case name. One, because
Vistra ITCL India Limited.
Vistra ITCL.
Just now, Anklet has.
So what is the name once again? Can you repeat the name once again?
VISTRA ITCL India Limited.
Okay, sir.
Where Vikram Bajaj is the RP.
Okay.
Just now I received this.
So
Company
they
Appeal
have.
80 2282 and 2283 of 2024.
Thank you, sir. Thank you. And in this case, it was held कि NCLT have the jurisdiction.
Yes. Even
Whether
if nothing is pending.
Okay.
Even if nothing is initiated, pending, nothing. Even then it is.
Okay. Thank you.
Excuse me, ma'am, I have a question. We are
Yes,
appointed as resolution professional in the for on behalf of personal guarantor by NCLT from the empanel list, and now we have received the objections from the council on behalf of personal guarantor that the petition filed by the financial creditor is not maintainable as it is time barred by limitation act. So whether as a resolution professional, whether we should continue filing report, as we have to file the report with.
Yes, ma'am. You should file your report properly, and FC will take the call on this. They can go for the appeal against if they have filing any application. I think application have been filed before the NCLT, na? So they
Yes.
will submit their reply on this. Ki how the application will not be cannot be considered this application.
Here
So
I can
you should. Yes.
Can I
Yes,
tell
sir.
something?
Yes. Yes,
That
sir.
COVID period exemption for 2 years, that whenever they are filing appeal, na, they are ignoring. But if you that consider, our application will not be time barred. You just see, you just check. In most 99%
Yes,
cases, I am also receiving.
because I was also explained the case here ki in which it was held since the case the loan was given in 1999 and the agreement was executed on 2005. However, the personal guarantor will be liable, and it was held by the NCLT ki this is time barred, but NCLT said this is not time barred. State Bank of India versus Gauri Shankar case. Please read this case also, and I will answer your query. Please properly file your report. Whatever the deadline has been provided, still they are taking any ground, you should continue whatever your responsibility you should do on a timely basis. Okay,
Otherwise,
ma'am?
also in my two,
Ma'am,
three cases, same reply
Yes.
is there. COVID period exemption is there. That's why
Yes,
it is
yes.
not time.
Yes,
That is
in
the
this
concept.
case also COVID exemption is also explained
Must
in
be
this
there.
case
Must
also.
be there.
Yes, yes.
Definitely.
SBI versus Gauri Shankar case, the same was mentioned.
and ma'am, as you have already mentioned, so it is confirmed now that from the period where we count limitation period starts from the demand notice, the date of serving of demand notice.
Yes, the limitation period will be started. Actually, this will also depend upon your guarantee agreement. If this is saying ki this is the continue guarantee, okay, ma'am. This is
Yes.
depend upon the language of your guarantee agreement also. Ki what is the language is being provided in your guarantee agreement. If this is a continue nature
And ma'am,
guarantee,
if there
yes.
and if it is not the deed is not of continuing guarantee, so what will be the date?
So the when they have served you the demand notice will be the date, and the COVID period will be excluded in counting of this.
Ma'am, I have one more query. In
Yes,
one
sir.
of the cases, actually, there was an MOU was entered between the corporate debtor and the alleged personal guarantor that they will be admitted to in the corporate debtor as a director and shares will be transferred to them. And for that, they have invested an amount around 3 crore 45 lakhs. So now there was a sanction letter in which it is mentioned that name of directors to be admitted and name of retiring directors. So now under the name of directors to be admitted, the name of personal guarantor has been mentioned, and accordingly the guarantee has been assigned to them and they have signed that sanction letter, the personal guarantor. But till date they have not been appointed as the director, and also the shares are not being transferred. It is a kind of cheating done with them. So in this case, can we appeal? Can we make an appeal to the NCLT that they have not been appointed as the director, so they cannot be treated as personal guarantor in that case?
No, no, ma'am. If they have executed the agreement, suppose you are saying ki they have executed an agreement.
Yes, for them to be appointed as director and that shares will be transferred to them, but both the
Okay, okay.
event has not been happened.
Okay, but he has executed the guarantee agreement. He has given any signature on the guarantee agreement. on which the loan was provided by the company to the creditor to the company?
Actually, they have signed it, the sanction letter through which the directors who were supposed to resign are relieved from the guarantee, and they are the burden is shifted to this personal guarantors. But in the sanction letter, it is written as to written to be appointed as the director, but they have not been appointed as the director.
Yes, so if you are saying कि there is some powerful ground in your case, you can go for the appeal, ma'am. You can go for the appeal. Maybe if they have not executed any guarantee agreement, if they have not entered in any guarantee agreement, they have not signed any paper related to the guarantee agreement, then they will
Yes.
not be liable for anything. He is
So, ma'am,
appointed
can
as
we
a director, the employee at the time. Yes,
can we
he
raise
was
a
the.
question on that sanction letter, that in the sanction letter itself you have
Ma'am, you can also file the operation mismanagement case against the company if the person have paid the because for taking the shares he has paid some amount to the
Yes.
company.
Ma'am,
So,
actually the cases have been filed, but the problem is that the financial creditor have filed the case against the personal guarantor, and now RP has also been appointed in that matter.
RP is appointed in the personal guarantor matter, and now
Yes.
personal guarantor want to file an appeal. He was not the personal, ma'am. Actually, only after seeing the document, the picture will be clear. Because on the face, I can't say whether the appeal will be allowed or not. Because this is only depend upon the facts and circumstances of the case.
Madam,
At the time of giving the guarantee, he was, yes, sir. Yes, sir.
can I clarify?
Yes, sir.
On the
You may.
basis of sanction letter, they cannot be held as guarantor. If they are not signed guarantee agreement, they will
Yes,
not be guarantor.
yes, yes.
Even if they
Only
have
the
acknowledged sanction letter, they are not guarantors.
guarantee
Sir,
agreement.
Guarantee agreement should be signed.
Sir, can I get any reference of the case you are referring that they cannot be considered as guarantors on the basis of the sanction letter?
Madam, I am a banker, retired banker. I know.
Oh,
On the basis of sanction letter, nobody can be held responsible. If bank
Sir,
is releasing,
how
if
can we
bank is,
prove this
madam,
before
just a minute.
NCLT?
If bank is releasing loan just on the basis of sanction letter, no documents are being
Not,
signed, then also they are
yes,
not held responsible.
actually, sir, what was happened? The deed of guarantee was executed between the erstwhile directors, and now they have been resigned. So the liability has been shifted
so,
to the
but
personal
no,
guarantor.
not shifted, ma'am. I just want to interrupt you. I have seen a case, the State Bank of India versus Gaurikisan.
Hmm.
In this case, the director has resigned from his position. However,
Yes.
the guarantee will be continue against him. He
Correct.
will be held liable as a personal guarantor in this case.
But ma'am, our client has not been appointed as director in the
So
company till date.
So I'm saying
erstwhile
कि
directors can be held liable.
erstwhile
Okay.
director will also be liable. I'm saying this. The erstwhile director liability will be continued. However,
Okay.
he has resigned from the position.
And now currently there are more two new directors have been appointed, and the liability has not been shifted towards them. It's only our client
Yes.
who are held liable for the
Madam,
personal
one
guarantee.
second, please.
So
Madam,
Yes.
can we also make an appeal that
madam, holding a person
yes.
as a personal guarantor, ठीक है?
Huh.
You cannot say, one cannot say only a director can execute a personal guarantee. Even if a person other than director or shareholder execute a personal guarantee, he will be liable.
Okay.
Whether
So
you are an employee, whether you are a
holding a
PA of the
directorship
company.
in the company is not a prerequisite to sign a personal guarantee agreement. This is one
Okay.
thing. Whether
Yes.
in that sanction letter is there any clause ki the guarantee will come in force only when he will become director, then only you can challenge it in the NCLT. If there is a clause if it which can directly relate to the personal guarantee and between the directorship, If he is appointed director, if the, in other words, in two words, if it is a conditional guarantee.
Yes, sir. In the
And
sanction.
if that condition is not fulfilled,
yes,
then you can take take this ground as a you see defense.
in our yes, okay. Yes, sir. So as I mentioned before, also in the sanction letter, they have mentioned that name of directors to be admitted and name of retiring directors. So
Yes.
here we can conclude that it is one of the condition for him for the respondent to become the personal guarantor in that case, because in the table they have mentioned that to be admitted as the directors, but they have not been admitted as the director.
That you have to go through the that sanction letter wordings about that
Okay.
condition very carefully. Then only you can take a stance in the court.
Okay.
And you can directly relate to the directorship to the with the personal guarantee. If it is if he is holding, only a director can give a personal guarantee, or if he is only in case he is appointed director, then only this guarantee will be executed, because the outgoing director, their guarantee is being waived off, because they are no longer a director.
Okay.
So that point may also come ki somebody has to give the guarantee, and guarantee is executed before he was appointed as director, and he signed the guarantee personal guarantee agreement, and thereafter he was not appointed as director. Then you can take the plea in the court of law, let the court decide, but you have to prove by the wordings of the guarantee of that sanction letter. If it is connected, these documents should be connected. Then only.
Okay. Okay. Yes, sir.
This is
Yes.
my personal.
Now,
Okay.
is there
Yes.
any other query, or we can conclude now? Participants, can we conclude now?
Yes.
Yes, yes.
Yes. Yes. Thank you so much, all the participants who take such initiative. And sorry for the some internet issues are there in today's webinar. However, all the participants till the end, they are connected in the webinar. So I'm very happy for the participation, and thank you to the ICSI IPA who has conducted this seminar on today's topic and giving the opportunity to speak today.
Thank you,
Over
ma'am.
to you, the ICSI IPA. Yes, thank you.